Welcome to another week with CyberTalk with Bob and Chris. And this week, it's more than just me and Chris ranting about cyber. And today we've got Joe Lazzarotti from Jackson Lewis. Welcome, Joe.
Hey, how you guys doing?
Hey, why don't you tell us a little bit about where you are, what you do, and why you're here?
Sure. I'm with Jackson Lewis. We're a national law firm located here in New Jersey. I co-founded and lead our privacy cybersecurity practice group. We do a lot of pre-breach and post-breach services for all kinds of industries, companies large and small.
Cool. Well, thank you for joining us this week. There's been a whole bunch of questions that Chris and I have been getting from people specifically about these FTC safeguards that go into effect on June 9th. In fact, we did a presentation a couple weeks ago to some CPAs, and the resounding message that came from that presentation was, we don't know about this, and why didn't the IRS tell us about it? And when we shared with them the information, they were like, wow, there's a lot of work that we have to do. And it actually just got us thinking that, maybe we need to talk to somebody that knows a little bit more about these regulations and who really needs to comply and why.
Yeah, we've seen some of the same things, done some work as well with, for example, tax preparation companies that struggling with some of the IRS rules, which some of the IRS publications also do mention the FTC safeguards rule as a path to getting compliance with safeguarding information in the process of tax preparation, as they may be considered, very likely are considered financial institutions, although they may not think of themselves that way. Certainly smaller tax preparation companies may not think of it that way. But the rule really is not specific to any particular industry. It's, are you engaged in activities that are financial in nature? And so you can find yourself being subject to the rule and not realize it, for sure.
Yeah, you meant, the fact that the regulation itself does list a whole bunch. It goes through a whole bunch of examples. Like, it does call out car dealerships as a financial institution, and then it goes through and even talks about property appraisers or even check printers. So it's a wide range, but it looks like they listing some industries in there, but there's probably others that if an ultimate financing arrangement happens with consumers, it's really where things are going. Is that true?
I think you have to obviously look at the details. I mean, because there are some exclusions from the rule. Even in the regulations, they say, like, if you're a retailer and you do, one of the examples is you do like a layaway, occasional layaway is not going to subject you to the rule. Just because you accept checks or credit cards from another, again, that's not going to trigger you. But if you're financing the purchase price of a product over time, and that's on a regular part of your business, that will likely put you in a position of being subject to the rule. That's a financial activity. So I think may get caught up.
So would that be like a home improvement contractor coming in and then offering financing on that, where he's actually turning that paper, bringing in a third party to do the financing?
It could. I mean, it very well could. The rule talks about certain activities that include, lending. That might be viewed as a financial activity for a company like that. So, sure.
Okay. Chris, what do you got?
I mean, I particularly like the payday loan lenders, so we could go with that. I'm not sure how well they feel about that. I've talked to a lot of CPAs about this. Like, most of them that are doing taxes, they just check the box when they do their PTIN, and they just say that they're doing the stuff, and they don't actually read it. I think that's what you're seeing, right? Similar situation. They just kind of they just check the box saying, hey, yeah, we're doing this stuff, but we're not actually doing it, or we're not really taking it seriously. So when we bring that up with people, it's kind of like a shock to them, but it's like, well, if you read what you were checking the box for, I guess it's like the iTunes end user agreement.
Yeah.
I mean, nobody reads it, I guess. I don't know, but like, I think the biggest thing for me, and I think the biggest thing that we've had in the feedback too, is how do you the 5,000 consumer record exemption? How is that calculated? How can a business look at what they're doing and accurately say we have less than 5,000 records? Because they are exempt from basically like four parts of it.
Yeah,
by being under 5,000 records.
I think that's something that, what's a consumer, someone that you're doing business with on an ongoing basis. And I think companies will have to look at that and see who they're interacting with over time. Obviously, one of the things that the FTC guidance talks about is you really have to continue evaluating your business. It's not just a one-time determination, right? Or in 18 months from when you look at it, you might have changed your business, you might have acquired enough consumers where you're over that threshold. But I think it's also important to note that you may be in a business and work and doing business in a state that has obligations that apply regardless, and that very much mirror these requirements. So you may come away from a determination and say, well, I have fewer than 5,000 consumers, or I don't really know if maybe it's less likely that I'm engaged in financial activities and not doing it all the time. It's only a few times. But there may be other laws that require you to have similar safeguards.
Yeah, right. I mean, I look at it and I don't think anything in FTC safeguards is something that companies shouldn't do. From looking at like what the requirements are, they're kind of like basic level requirements that most businesses today should be doing. But a lot of people want to focus on that 5,000 rule because they're like, well, can I do less?
Yeah, I think that's exactly right. I mean, at the end of the day, if you have 4,000 consumers and you have a data breach, the question is going to be, what did you do to safeguard my data? How did this happen? I mean, we see that all the time. And, you're exactly right. These are basic best practices, essentially, that really any company shouldn't have trouble putting together. So, again, that's the same kind of advice we give to clients. You can quibble about whether you meet a particular threshold, and I'm not suggesting that everybody do things that the law may not specifically require, but as a business owner, it's important to think about what kind of data you're maintaining and having those safeguards to avoid as best you can unauthorized access to that data.
So one of the things that came up with on the CP, specifically with the CPAs and bookkeepers we were talking to was, are we counting records that we personally have or that we have access to because I happen to be getting in and seeing all my client billing information as part of this, a part of my normal business?
You mean if as part of your business, your client customers?
If I'm doing all the billing and all billing reconciliation for one of our clients as a bookkeeper, and do those 20,000 clients pieces of data count as something that I should be protecting also?
I'm not sure if the guidance addressed that. I haven't seen that issue. But I know that the term consumer is defined as a consumer of the business. And the consumer of the financial institution, quote unquote, customer wouldn't be their consumer, right? What you're talking about.
Direct consumer.
Yeah. So I don't know that would be the case. But the issue then becomes, right, if you're an accounting firm and you have a client and the accounting firm's own consumers is below 5,000, but it has clients that have many more thousands of consumers, those clients are financial institutions, let's assume, right?
Yeah.
Obligated to have an agreement with the accountant that says, you safeguard this data, you're going to push down to you similar obligations. So even if you're not within the scope of the FTC safeguard rule, you're going to find yourself in that, basically in the same position by contract, because your clients have to do it, and they should be pushing those obligations down by contract. So those numbers may still get you there, I guess, is another way of saying.
And I think that's what we were kind of confused about, because like like in that situation, let's say you have a customer, like you said, that has 5,000 consumer records and they fall underneath this, and you are a CPA that's doing all that. What, and I know this is kind of tough to say, but like if you do something that gets them breached, I mean, they're probably going to sue you, right? Like if you're not safeguarding the data,
They could. I
I mean,
mean,
they could, right? Yeah.
I was just reading an article the other day. I mean, there was I don't know the exact dates, but it's talking about how data breach litigation is kind of on the rise. I think like over
Yeah.
the last 10 years, I think there was something like 4 out of 400 breaches resulted in a lawsuit, and now it's up to like 40 or 50 breaches out of 400 or 500 result in a lawsuit. So it's kind of like gone from 1% to 10% of breaches that result in some kind of litigation, and a lot of those cases boil down to negligence. And also, if you're a company, if you're the CPA firm, you may and your client gives you their data, and and you have the breach, it's your client that technically, as the owner of that data, that has the obligation to notify, and they could be brought into the suit because maybe they didn't, it's alleged, take adequate steps to verify whether you as the accounting firm had appropriate safeguards. So there's liability that potentially can go around, and these cases are certainly increasing.
And that's one of the, that actually really just stresses the point you made before that, part of the FTC safeguards is you have to vet your vendors.
Mm-hmm.
And, this is, you can't necessarily protect all your own data yourself. You really are pushing back to your other vendors and pushing it upstream, and really having a process to vet and revet the vendors you're using.
And yeah, and just to add to that, I mean, one of the things we're seeing as well is for financial institutions, a couple of years ago, the DOL put out guidance where retirement plan sponsors have a fiduciary duty to vet their service providers. So if you're in the retirement plan space, maybe you're an auditor, maybe you're a CPA firm working with employer-sponsored retirement plans, you're getting questions from your customers saying, "Hey, what are you guys doing?" And they may not be focused on the FTC rules. They may not be aware that they may also apply to you, but they are going to have a list of safeguards that they're expecting you to have in place if you want to continue servicing their retirement plan, which is really what the DOL is requiring them to do, and it's a fiduciary duty. So, we do a lot of work with retirement plan sponsors and helping them to figure this out, because the interesting thing is this is coming up now in DOL audits. And the DOL is not just asking for plan documents and written policies. They want to see the conversations, the email traffic between the plan and the service provider to see exactly what steps were taken to assess cyber. So it really, seems like the federal agencies anyway are kind of clamping down on this to see exactly what's going on.
Well,
I think what CISA is doing, like to that point, like what CISA is trying to push down on, like critical infrastructure and things like that, like you're just gonna see more of it. From a government standpoint, I mean, obviously we don't want to wreck people's retirement funds either. That's kind of get the retirement taken. But I think for me, the thing that is so confusing for the FTC safe when you talk to people is that they focus on the exemption, they don't know about it, or they haven't made the financial commitment in their business because they weren't prepared for it. So I think maybe talking about like what is the financial impact of this on their business, or what is the impact in general on their business if they don't do this? If they just say, hey, you know what, screw it, we're just not going to do it.
I mean, I think that that varies business to business, but
right.
We'll say as a practical matter, right? You want companies to go through the right steps, but small businesses are just going to have difficulty doing that at times. But there are basic things that can be done. I mean, what we see it. We do a lot of data breach response work, and many of those cases are business email compromise cases. And if you may say, well, I'm not really concerned about a lot of personal data that we don't put that in email. Okay, but if you're doing mentioned pools, right? So if maybe you're transferring large money or real estate transactions, and your email gets compromised, bad guys get into your email and they wind up causing you to misdirect funds that could be
Every day.
$100, and you're out that money, or your client's out that money. They're going to be looking to you to make good on that. And so it's not even someone's social security number. It's a matter of someone able to get into your email. And one of the things in the FTC rules is having multi-factor authentication, which, I'm not an IT expert, but talk to any IT expert, and that's the first thing they'll tell you should be implemented. And
it's also free.
Yeah, and even trying to get coverage before they'll underwrite you, increasingly they're requiring things like that. So, putting in place those kinds of safeguards, having a basic policy with employees, basic training, these are things that really could be done relatively inexpensively. So,
So we are just about out of time here, Joe. We could probably have you back for at least a dozen more different sessions around this. But right now, why don't you tell people how people can get in touch with you?
Yeah.
Should they actually want to talk about a cyber issue or any other of your services?
Sure, thanks. Definitely reach out by phone. My direct is 908-795-5205. My email is joseph.lazzarotti@jacksonlewis.com.
Cool. Well,
awesome.
Thanks, Joe. This has been awesome. There's so many things going on in the cyberspace that I know Chris and I both need to get back to some other stuff. Chris, any closing
Don't worry,
comments?
we're just going to quote you on another webinar we're going to do. We're not really going to quote you, but like we'll use some of this because I think we learned a lot. We get a little more clarity on the 5,000 exemption rule. And like I said, I think it's something that everybody should be doing anyway. I really don't think this is like something crazy. I think people just need to understand it's there and just go follow through with it. But
and for anyone else that's been watching, comment below for any other future topics you'd like to hear from me, Chris, or Joe, because we could certainly go in and unpack a business email compromise because, as Joe said, it can affect both you and your money. Have a great time, guys.
See you. Have a good week.